Okay, jury members, I previously read to you an instruction on evidence of character. There was an error in the instruction. I'm going to read to you the corrected instruction, and this is the instruction that will be in your written instructions that each of you will be given a copy of. In this case, you have heard evidence as to the defendant's general character of being peaceful and law-abiding. You should consider such evidence with all the other evidence in the case in determining whether or not the prosecution has proven the defendant's guilt beyond a reasonable doubt. Now, I told you I would give you some additional instructions prior to you going to deliberate. As I indicated before, each of you will be given a copy of the written instructions. The lawyers and I have determined that these instructions contain all the laws that are necessary for you to know in order to decide this case. I can't give you a trial transcript. No such transcript exists. We count on the jury to rely on his collective memory. If you have a request to have a portion of a witness's testimony read back to you by my court reporter, I will consider the request in consultation with the lawyers, but that request may be denied, in which case you'll be asked to rely on your collective memory. If you submit a question to me about the law or evidence, I will need to consult with the lawyers before deciding whether I can answer the question. Because the lawyers and I may be in other hearings, it may take a significant amount of time to respond to your question. I say this not to discourage you from asking questions, but only to inform you that the asking of a question about the law or evidence is a significant event that takes time to address. Now, you've been allowed to take notes during the trial. You may take those notes with you to the jury room. You should not consider these notes binding or conclusive, whether they are your notes or those of another juror. The note should be used as an aid to your memory and not as a substitute for it. It is your recollection of the evidence that should control. You should disregard anything contrary to your recollection that may appear from your own notes or those of another juror. You should not give greater weight to a particular piece of evidence solely because it is referred to in a note taken by a juror. In this case, the state and the defendant have agreed that you will be sent back with a laptop containing all of the video and audio evidence admitted in this case. This is by order of the court. The attorneys have reviewed the laptop to ensure the accuracy of the exhibits on the laptop. You will have a laptop that does not have internet access or other programs or information on it. The only items on the laptop are whatever is needed to access the exhibits that are on the laptop. On the laptop, you will see each exhibit identified by number. You can simply click on the exhibit and it should open on the laptop in an additional monitor that has been provided for you in the deliberation room. If you encounter any difficulty operating the laptop or accessing any exhibit, you may send a note to the deputy who will be outside of your deliberation room. I will then review the note with the attorneys and an IT person and see if the issue can be resolved. If the issue cannot be resolved, we may need to replay the exhibit or exhibits in the traditional manner, with the judge, parties, and jury reconvening in the courtroom and replaying the recordings in open court, and with the jury suspending your deliberations during that time. After we replay the recordings, you will then return to the jury room to continue your deliberations. When you return to the jury room to discuss this case, you must select a jury member to be foreperson. That person will lead your deliberations. Now, we all have feelings, assumptions, perception, fears, and stereotypes about others. Some biases we are aware of and others we may not be fully aware of, which is why they are called implicit or unconscious biases. No matter how unbiased we think we are, our brains are hardwired to make unconscious decisions. We look at others and filter what they say through the lens of our own personal experience and background. Because we all do this, we often see life and evaluate evidence in a way that tends to favor people who are like ourselves or who have had life experiences like our own. We can also have biases about people like ourselves. One common example is the automatic association of male with career and female with family. Bias can affect our thoughts, how we remember what we see and hear, whom we believe and disbelieve, and how we make important decisions. As jurors, you are being asked to make an important decision in this case. You must take the time you need to reflect carefully and thoughtfully about the evidence. Think about why you are making the decision you are making and examine it for bias. Reconsider your first impressions of the people and the evidence in this case. If the people involved in this case were from different backgrounds, for example, richer or poorer, more or less educated, older or younger, or of a different gender identity, race, religion, or sexual orientation, would you still view them and the evidence in the same way? Listen to one another. Resist and help each other resist any urge to reach a verdict influenced by bias. Each of you have different backgrounds and will be viewing this case in light of your own insights, assumptions, and biases. Listening to different perspectives may help you to better identify the possible effects these hidden biases may have on decision making. Resist jumping to conclusions based on personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or unconscious biases. The law demands that you make a fair decision based solely on the evidence, your individual evaluations of that evidence, your reason and common sense, and these instructions. In order for you to return a verdict, whether guilty or not guilty, each juror must agree with the verdict. Your verdict must be unanimous. You should discuss the case with one another and deliberate with a view toward reaching agreement, if you can do so without violating your individual judgment. You should decide the case for yourself, but only after you have discussed the case with your fellow jurors and have carefully considered their views. You should not hesitate to re-examine your views and change your opinion if you become convinced they are erroneous. But you should not surrender your honest opinion simply because other jurors disagree or merely to reach a verdict. A single verdict for each count has been prepared for your use. Now, the order in which the guilty and not guilty choices appear on the verdict forms is strictly alphabetical and should not in any way be considered as indicating which choice is the correct choice. And the verdict forms basically say, verdict count 1, we the jury on the charge of manslaughter in the first degree while committing a misdemeanor on or about April 11, 2021 in Hennepin County, State of Minnesota, find the defendant, and then there's a space to check guilty or not guilty. And the second verdict form is on count 2, we the jury on the charge of manslaughter in the second degree, culpable negligence on or about April 11, 2021 in Hennepin County, State of Minnesota, find the defendant, and then there's a space for guilty or not guilty. When you have finished your deliberations and have reached a verdict as to the specific count, the foreperson should mark the appropriate choice on the form with an X. The foreperson then must date and sign the verdict form with the foreperson's juror number. When you agree on a verdict, notify the deputy. You will return to the courtroom where your verdict will be received and read out loud in your presence. In arriving at your verdict, the subject of penalty or punishment is not to be discussed or considered by you. This is a matter that lies solely with the court and within the limits prescribed by law. The subject of penalty or punishment must not in any way affect your decision as to whether or not the state has proven the charges beyond a reasonable doubt. Your duty is to both the state and the defendant. The state and the defendant both have the right to expect that you will see that justice is done according to your true conclusions. The responsibility which rests upon you should be borne courageously and without fear or favor. Be fair, act honestly, deliberate without prejudice, bias, or sympathy, and without regard to your personal likes or dislikes. Now, members of the jury, this case is in your hands as judges of the facts. I am certain you realize this case is important and serious and therefore deserves your careful consideration. We will await your verdict. And thank you again, members of the jury, for your attention. In this case, I really appreciate, and I think everyone here appreciates you being here. All right, so now it's time for you to do your job. Oh, excuse me. I am so sorry. I have to dismiss the alternates in this case. It's alternate number 58 and 57. And I'm so sorry that you sat through all the evidence and was unable to deliberate with your fellow jurors. My staff would be happy to let you know what the result is if you wish. So thank you very much. You may gather up your things from the jury waiting room, and your service is both appreciated and over. Thank you. Would the deputy please come forward and be sworn by the clerk?
You affirm that you will keep these jurors together, separate from all other persons, and you will not allow anyone to communicate with them or overhear their deliberations, that you will not make any comment to them about the law or facts in this case, and that you will not disclose to anyone except this court anything which you may learn from their deliberations. If so, please say, I do.
I do.
All right. Good luck, members of the jury.